Godfred Dame is also, on the other hand, saying something else.
Yes. So for the first time, you're having a former Attorney General and you're having a present Attorney General throwing words. In fact, in relation to what has happened over the course of the week, we have the current Attorney General, Dr. Dominic Ayine, coming to explain or justify his decision to withdraw cases that he felt that as the way the cases are, he thinks that one, if the cases are allowed to go through full trial, the state will lose them. And on top of that, the state will waste a lot of resources in seeing those cases. So the best faith is to, on his, upon analyzing the situation, upon wide consultations, he decided to truncate those cases. Some of them, null protocol was entered, some of them to withdrawal, and accused persons are acquitted and discharged in relation to all of that. Then the explanations that he gave to those actions, the former Attorney General Godfred Dame saying that no, that ought not to be. And Dominic Ayine is not giving us the right picture of what has happened and to justify the decision that he's making. The point that he's been making is the fact that he notes that in relation to one of the cases, Dr. Johnson Isiama Pandit, the current Attorney General indicates that, look, he came to see a memo that was prepared, and then the memo points to the fact that Dr. Johnson Isiama should be discharged from the Unibank and then the UT case. So that was not dealt with before he came. So when he came in, upon having a discussion with the state attorney, the DPP, and he thinks that once that has been prepared already, then he has to carry it on. And he did that by dropping charges against Dr. Isiama. The AG is saying that there was no such memo in existence. So he's challenging Dr. Ayine to produce that particular memo. Let's hear from Godfred Dame on that subject.
Dr. Ayine's explanation
but the memo is
for discontinuing the case against Johnson Pandit Isiama. It's a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, purportedly, as Dr. Ayine stated, and I quote him, recommending that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists. No such memorandum exists. I do not recall receiving any such memo from the prosecution's division. I challenge Dr. Ayine to produce such a memo for the examination of the public, as he has started saying to the public at a press conference conducted by him as a basis for his impugned actions.
That is former Attorney General Godfred Dame making the point that there's no such memo. But in the course of making that point, he makes something very interesting. He made a point that there's no such memo. And at the same time said that even if there is such a memo, does it mean that the opinion of the DPP and the state attorney should be accepted holistically by the Attorney General? The Attorney General's opinion cannot be the opinion of those who prepared such memo. So what is he saying? What is the point there? You have to just read in between the lines, and then you know what is happening in relation to whether there is an existence of a memo or not. But we are also hearing about the hard copy cannot be traced, but we are hearing about some
email trace or soft copy somewhere.
He's challenging Dr. Ayine to produce that evidence, and I'm sure that
maybe this morning Dr. Ayine should put the email trace out. I mean, yeah.
But that is not all. Godfred Dame is saying that, look, the actions of Dr. Ayine is just to whitewash NDC officials who were implicated and charged before court. Let's hear him again.
I say that in any event, if the Attorney General also the considered view that the sum of $2 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only one out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayine does not fault? and did not talk about.
So that's
yes. So that is Godfred Dame. He said, "Look, Honorable Ayine, you are whitewashing all the NDC previous appointees on the crimes that have been leveled against all of them and all of that. But Lily and Lantam, in relation to all the cases that have been addressed or that have been mentioned, there were some of them, in fact, all the cases that have been dropped so far, I have followed those cases religiously in court. And so at all material time, when you ask him about what happened in those cases, I have fair idea of what has happened in relation to that. Now, let me tackle Saglemi affordable housing. The Saglemi affordable housing case, and your screen now is the first page of the charge sheet that was filed by the former Attorney General. And this one was on the 30th of July, 2021. And this particular charge sheet referred 70 counts against Alhaji Collins Dauda and then the 4 others. One of the accused persons, in fact, Andres Clocanas, that's the 4th accused person, is deceased. But for the purposes of our viewers, let me just walk you through those who were on this charge. The Republic versus Alhaji Collins Dauda, Kweku Ajiman Mensah, Alhaji Ziblim Yakubu, Andre Clocanas, who is deceased, and then Nuve Tete Angelo. Alhaji Collins Dauda is the former Works and Housing Minister, the same as Kweku Ajiman Mensah, also a former minister. Then Alhaji Ziblim Yakubu was the former chief director. Then Albert Clocanas is a businessman. He is a contractor in the matter. And then Nuve Tete Angelo is a businessman. So the 5, in fact, have been charged for 70 counts. But look at the subject of contention will be the count 1. Banini, please go to the next stage and let me just walk you through what count 1, the offense, absolutely. So, statement of offense in relation to count 1 says that what? Intentionally misapplying public property contrary to section 1(2) of the Public Property Protection Act 1977, SMCD 140. And when a statement of offense is read out, it has to come with the particulars of offense, or particulars of that offense will have to be explained. Now listen to the listen to the particulars of offense. Alhaji Collins Dauda, between February 2014 and December 2016 in Accra, in the Greater Accra region, you intentionally misapplied the sum of $200 million belonging to the government of Ghana by causing the said amount, which had been approved by the Parliament of Ghana for the construction of 5,000 housing units to be applied toward the payment of 1,412 housing units under the Saglemi Affordable Housing Project. What I want you to pay attention to is the sum that is said that
the $200 million.
$200 million. Great. So this was the first count 1, the first of the charges that was preferred against Alhaji Collins Dauda. Now, at the press conference, in the course of the trial, lawyers of Alhaji Collins Dauda, led by Thaddeus Sori, was scrutinizing or cross-examining the state witness, the first prosecution witness, Dr. Reverend Yaosei, the current chief director of the ministry.
Okay.
One of the issues that came to the fore was that you are charging the man for misapplying $200 million. And all of us here are familiar with how, even if you are seeking for loan, how it works. If you are asking for 200 million, charges will be deducted from this sum. And so the amount that will hit your account will not be $200 million. And he said that the man has misappropriated $200 million. In the course of the trial, it came to the fore that over $1 million were charges on this sum. So at the time that this sum was arriving in the Bank of Ghana as a money, physical cash that can be used for anything, it is less than $200 million. So we're asking Attorney General Godfred Dame, your first count against Alhaji Collins Dauda was that he has misapplied $200 million. Are you charging him also on the charges of this particular money? The man said no, he didn't charge Alhaji Collins Dauda with misapplying $200 million. But his own charge sheet, this is it, count 1. So Alhaji Collins Dauda was to answer to charges on this money when the charges were not applying. But let's hear from the question that I asked Honorable Godfred Dame in relation to why he's charging Alhaji Collins Dauda on charges on that particular sum of money.
I will respect affordable housing matter. The sum in question is $200 million. So Alhaji Collins Dauda and then the four others, unfortunately, one of them is deceased now. In the course of the trial, I remember when the very first prosecution witness mounted the witness box, Reverend Yao Osei. One of the issues that came to the fore was that if you look at the sum of $200 million, charges alone amounted to over $1 million. And therefore, on what basis are you charging Alhaji Collins Dauda to have expended $200 million when charges took away some of the money?
It is never true that we charge Collins Dauda for financial loss in the sum of over $200 million. Indeed, each of the financial loss offenses is built around a specific sum that an accused person can actually be held to have caused. So, Dada authorized the payment of certain sums when he was in office. They didn't amount to $200 million. Those form the subject matter of the offense of willfully causing financial loss. And as I say, it must be distinguished from intentionally misapplying public property, which is his authorization for the application of the whole $200 million for the construction of 1,412 housing units, when indeed Cabinet, Parliament of Ghana, and PPA had approved that the entire $200 million should be used to construct 5,000 housing units. So his directing wrongly an application of $200 million for a number of housing units far less that had been approved by Parliament and by PPA resulted in his being charged with that offense. So there's really nothing wrong that has been done in the Collins Dauda matter. Our charges, perhaps you are calculating because each of the counts has specific sums with which an accused person can be linked.
So that is Godfred Dame, the former Attorney General, responding to questions as to why he charged Alhaji Collins Dauda for misapplying $200 million. And you heard his response. And he said that, look, he never charged Alhaji Collins Dauda. But the very first count,
on
the
first count
was misapplied $200 million. And in the course of the trial, one of the things that, in fact, if you listen to Dr. Ayine's explanation, he said, look, there were so many people, even Honorable Atachian's name was mentioned, the kind of things that Collins Dauda did that landed him in court. It was the same thing that Honorable Atachian also did. Then if you are charging people, why don't you charge all of them? But you selected a few. Of course, it is the view of the Attorney General. It's the Attorney General's discretion to charge who you want to charge. Right. But the point is that you also have to adduce evidence that will be substantial enough to convict them. And I remember so many times, Justice Ernest Owusu-Dapa will make the point that, look, prosecution, if you are not ready, come for your case. If you are ready, then you come back and all of that. So that is just a bit in relation to the Stagleme affordable housing case and why the current Attorney General thinks that the case should be off, and the former Attorney General thinks that, no, the case should continue.
The state should continue.
And there's another of the cases that is also in contention, Cocoa Board. Dr. Stephen Kobno-Puni and Seidu Agongo. That was also an issue that came to the fore. And in the course of this trial, one of the contentious issues, or one of the controversial matters that came to the fore was that one of the state witnesses, Dr. Edouard Poma, the third prosecution witness, who in fact is the complainant in this matter, swore an oath and testified. Lawyers of Dr. Stephen Kobno-Puni thought that, no, the man lied on oath. So they filed a motion and won the court to commit him for prison for perjury, for lying on oath. And on the 29th of June 2020, when the case came before Justice Clement Henyenuga, a justice of the Supreme Court, now retired, the hearing of the perjury, this is what happened. And this is what Justice Clement Henyenuga said in relation to when the lawyers want the application to be moved. He said, it is my opinion that to avoid prejudice and ensure fair play and justice, it was desirable that the motion be adjourned sine die. The motion be adjourned sine die, if you like, sine die, or if you like, indefinitely. That's what it means. So on June 29, 2020, this application to commit Dr. Edouard Mpoma to prison for lying on oath was adjourned indefinitely. Until today, the case has never been, that particular motion has never been moved. At the press conference, Godfred Dame made the point that yes, it was heard, and then it was determined by the court as whether it was granted or dismissed. He didn't say it. But lawyers went to the Supreme Court to say that no, the High Court cannot adjourn the case sine die. It has to be dealt with before they deal with the matter. But it was adjourned sine die. So that is one of the issues that came to the. In the course of the trial, I'm just giving you some systemic challenges that the judiciary normally will face. For those who remember, the ambulance case, Dr. Kesela Tofosi and Richard Jakpa were acquitted and discharged by the Court of Appeal. And their application to the Court of Appeal were to challenge submission of no case that they filed and then it was dismissed. And the court asked them to open their list. But look at, what I want you to pay attention is, look at the time. This letter was authored from lawyers of Dr. Stephen Komopuni on the 12th of December, 2024. But I'm going to read the letter to you and pay attention to the dates that were carried out in this particular letter. And the heading is, request for date for judgment in criminal appeal, the Republic versus Dr. Stephen Komopuni and two others. And two others is Said Wagongo and Agricort Ghana Limited. The above matter refers to, we act as solicitors and on instructions of Stephen Komopuni as appellant. Appellant appeal against the ruling of the High Court Land Division presided over by Justice Clement Onyenuga, Justice of the Supreme Court, sitting as an additional High Court judge, which dismissed the appellant application for submission of no case in a suit, and they mentioned the suit number. The Court of Appeal on the 21st day of July 2022, 21st day of July 2022, and this letter was authored 12 December 2024. That's almost about 2 years difference. Later. Okay. Presided over by Justice Henry Anthony Kofi, that's the current Association Magistrate President, consisting of Justice Samuel Esiedu and Richard J. Frimpong. Now, all of them are at the Supreme Court now. Ordered the appellant and the respondent as the prosecution to both file their various statement of cases within 21 days. And the court adjourned the matter to the 19th of October 2022 for judgment. 19th of October 2022 for judgment. Appellant and respondent filed their various statement of cases on the 9th day of August 2022 and on the 1st day of September 2022, respectively. The court did not sit on the said day, 19th of October. Hence, the judgment was not delivered. We will be most grateful if the case fixed on the date for judgment to be delivered. And as at December 24, there is no judgment in relation to the submission of no case that they are appealing at the Court of Appeal. Granted that the High Court has proceeded with the decision, the trial at the High Court, and they are convicted and sentenced. And the Court of Appeal now comes to say that, yes, we think that a similar thing in the ambulance case happened. What has it become of it? It means the accused persons were wrongfully going to be in custody or in incarceration while they have done something wrong. So that is how sometimes the system is not too favorable. An application filed in 2022, as of December 2023, 2 years apart, it has not been dealt with and all of that. So that is one of the things in relation to Cocoa Board. And the same Cocoa Board, one of the things that Dr. Ayine indicated was the reason of truncating the cases was that prosecution relied on scientists, no end user. The accused person called farmers to come and testify. Farmers who said they have used low-level liquid fertilizer, and he gave them yield, including the 2019 best farmer. He said he used little-level and it worked for him. He bought his cars, he's expanded his farm, he built his houses. Prosecution didn't call. So at the press conference, I was asking Godfred Dame, the prosecution, your team, relied heavily on scientists to prove their case. The fertilizer was not on the field. There was no an end user to say that, yes, I used the fertilizer and it didn't work for me. But the accused person brought farmers from the farm. So I wanted a response from the Attorney General.
Attorney General.
Absolutely, former Attorney General. Do you not think that is the reason, or is it expedient enough for this to wash? He said that, look, this is a scientific matter and all of that. But I think that in the coming days, or people will have their own views and share in relation to all that has been said in this interesting cases that are pending in court.
Let's look at some of the cases coming up today. Bishop Salif Amako is back in court.
Yes. So you notice that the issue about his son, that case is dealt with. His son has been sentenced to Senior Correctional Center for 6 months and all of that.
So he's there?
He's there. We'll confirm again whether he's there, but what we do know is that Senior Correctional Center.
I like the bit you added. We'll confirm again. Yeah, this is Ghana.
That is the order of the court, that he should be there. We'll find out whether he is there. So the father, the mother, and then one sales assistant were charged for allowing him to drive without having a license and all of that. So they are on that particular charge. Today, they are back at the circuit court, and at the last court sitting, the indication was that prosecution was going to amend the charge sheet, but we'll be there to see what will happen in relation to this particular leg of the matter. Apart from that, there's also another case at the High Court that we have been following, Gregory Afoko. Yes, Gregory Afoko. The retrial is on. And then the fifth witness has testified. Today we expect the sixth to be in the witness. But in one of the cases that Dr. Ayine has been talking about in relation to the fundamental human rights or the innocence of an accused person. And remember that since 2016, when this incident happened, Afoko has still been in lawful custody. So we'll know more when the matter comes before Justice Marie Lewis Simmons and the parties appear. And then the very last, of course, is the treason felony.
Yeah,
Back at Vomawo. That case is also pending at the court. Today, what Justice Mary Mamiko Yenzu intends to do is to supervise the selection of the new jurors. The last one that they had, because of systemic issues, they have to let it go. So today, the expectation is that Oliver will come to court and he will select his own jurors. As to whether that will happen, we'll be there to bring you updates in relation to that.
Absolutely, Counsel. Thank you very much.
Thank you, Lily, and thank you, Lantam, the Manchester United fan who now ask them where they are.
Add proud Manchester United.
Ask them where they are on the table.
Even if we are at the bottom of the
where
table.
are you on the table?
You are the real Olofufu.
Arsenal is second.
You are the real Olofufu.
Arsenal is second on the table.
Anyway, Captain, thank you very much.
If we are bottom of the
We'll
table,
catch you
we are
definitely
proud.
on the flip side.